If someone dives headfirst into a shallow lake despite the warning signs, or goes swimming in a harbour in the middle of the night, or maybe gets shot breaking into a shed, can they actually sue the property owner for damages? Believe it or not, the UK courts have had to decide cases just like these. In this short clip from Astranti's CILEX tuition course, we look at some of the most memorable cases involving trespassers and occupiers liability and show you the legal principles you need to understand for your exams.
One of the most important cases of interpreting Section 1.3 of the Act, i.e. those three criteria, is Tomlinson and Congleton Borough Council. This case concerned a young man who suffered a catastrophic injury after diving headfirst into a shallow lake at a country park, despite signs saying no swimming. When he entered the water, he was classed as a trespasser. The court's first task was to ask whether the injury arose from the state of the premises, as required by Section 1.1a, and the answer was no. The lake was not unusually dangerous. The claimant's injuries were caused by his own actions, not a hidden hazard created or left by the occupier. The next question was the critical analysis of the risk. It was accepted that the council knew people swam in the lake, despite the warnings, and they were also aware that some of them, particularly teenagers, engaged in risky behaviour. So the first two conditions had been met. The council knew about the danger and that people might come into its vicinity. But the claim ultimately failed on that third requirement. The risk was not one that the council should have taken steps to protect against. People must take responsibility for the dangers inherent in activities that they freely choose to undertake, and it would be extremely rare for an occupier to be under a duty to prevent people from taking obvious risks. Imposing that kind of an obligation, especially on public authorities with limited resources, would be unreasonable, or so the judges stated. Therefore, although the council knew about the danger and the likelihood of trespassers, the court held it was not reasonable for them to prevent it. No duty arose, so the claim ultimately failed. There were some other similar trespasser cases, including Rhind and Asbury Water Park. In this case, the claimant was injured after diving into a lake to retrieve a football, ignoring warning signs that were around the lake. He struck a submerged object invisible from the surface, but the court found that the occupier had no actual or reasonable awareness of the hidden hazard, and therefore no duty of care. Then, in the case of Donoghue against Folkestone Properties, a man was injured diving into a harbour after midnight in December, and the Court of Appeal held that the occupier did not owe a duty, as it was not reasonable to expect them to foresee that someone would be in that location at that time. Therefore, the conditions of duty of care had not been satisfied. Finally, the case of Swain against Puri involved a boy who entered a factory through a hole in a fence and was injured. Because the occupier had no reason to believe that children would be on site, there was no duty owed. But in the case of Pendle Point Plaza, Eva is a child and children are entitled to more protection than adults, where their presence can be anticipated. Here, the broken fence and the inviting mural make it far more likely that a court would find that Eva's injuries were foreseeable and preventable, especially if fencing her out or removing the mural was low cost. The same principle might apply to Anya, although courts tend to be more cautious with adult trespassers. As we've just touched on, the cost and the practicality of imposing a duty on occupiers is taken into account. This is especially the case for public bodies. And in the case of Simons against Isle of Wight Council, a pupil was injured on swings near a sports day field, and the court refused to impose a duty on the school to restrict access to the park. It held that the financial cost of preventative measures would be unreasonable. Things like cordoning off the area and things like that would be unreasonable and potentially uninsurable, meaning the final condition had not been met. So, the standard of care under the 1984 Act, if all three conditions have been met, is to take such care as is reasonable in all the circumstances to see that the non-visitor does not suffer injury by reason of the danger concerned. This is a lower standard than the 1957 Act, which, if you can remember, was to ensure that the visitors are reasonably safe. And the court will take into account quite a few different factors, including the nature of the premises and the severity of the danger. How serious is the risk? They will also look at cost and practicality, i.e. how expensive or difficult would it be to prevent the risk. They look at the vulnerability of the claimant, i.e. the trespasser, so whether they are a child or otherwise vulnerable. And they look at any warnings given, where there are clear signs, for example, or barriers. Courts will then balance these factors, and they are reluctant to burden occupiers with obligations towards people who have entered without permission. It's also important to note that when the trespasser is performing a criminal activity, this doesn't necessarily mean that they are not entitled to any protection. This is best explained by analogy. So in the case of Revill and Newbery, a man was shot by an allotment owner while attempting to break into his shed. The court refused to deny liability just because Revill was committing burglary. Instead, such illegal conduct is addressed through contributory negligence, not total exclusion from protection. So an occupier does owe a duty of care to trespassers even when their presence is unlawful, and the court in this case chose to award damages, although these were reduced for the contributory negligence.
So as these cases show, occupiers' liability to trespassers can produce some pretty surprising results. For your exam, the important thing to understand is how the courts balance the occupier's duty of care against the claimant's own actions and personal responsibility. If you're studying on the CILEX Foundation course, you can get 4 free mock exams from Astranti to help you practice under exam-style conditions. Just follow the link in the description to get access.